Hey, brothers and sisters. This is Sister Kristen, otherwise known as Misconduct. And for those of you who are going into the new year and dealing with court cases, this one is for you. I'm happy to report that the Superior Court of California has accepted my bond. So I'm going to show you exactly what I did so you can understand what to do with your court case. Now, creditors and their bonds. Go read it. It's an easy read. You'll be glued to the edge of your seat, and it will give you a correct understanding about what is happening in the courtroom. This is an example of the bond that I used. It's a simple one-page document. Okay? In the corner, your proper name, address. I used authorized representative instead of in pro per. You can also use sui juris, but you are the authorized representative of the all caps. Make sure you use the correct address, the one that you have on file with the court, or they'll send it back to you. Now, in my case, I was the plaintiff. Now, you should always be the plaintiff, but that's not always the way it works out. This bond will work for you whether you are the plaintiff or the defendant. This is exactly how I did mine. There appearing no bond of record to initiate the matter regarding case number blah 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 and associated accounts, I, your proper name, undertake as follows. In consideration of the fact that no lawful money of account exists in circulation, and in consideration of the fact that I have suffered dishonor regarding the matter of case number blah 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 and associated accounts, I underwrite with my private exemption number, your social security number with no dashes, any and all obligations of performance, loss, costs sustained by the Superior Court of California, County of San Francisco, and the respectful citizens regarding said matter. Date and signature. This is a sample of the letter that I sent to Janet Yellen, who is the Secretary of the Treasury, to let her know what's going on. In the right-hand corner, you see the dotted lines. The sticker from your certified mail goes there. Notice of pre-authorized use of credit. Regarding account number is your case number. Miss Yellen, I hereby authorize the Superior Court of California, County of San Francisco, and its officers, administrators, and accounting clerks to utilize my exemption through Fedwire, through the TTL account of Claimant's Bank, to settle the above referenced account by adjustment and offset through the undersigned's private set-off account as follows. Credit to the order of Superior Court of California, County of San Francisco. Amount, in my case, I'm suing my previous landlord for $864,000. Make your bond for the amount that is twice the amount of the court case. In this case, $1,739,000. For further credit to account number, your case number here, debtor is your name in all caps, and the debtor's number is the Social Security number with dashes. Set-off account number is your Social Security number without dashes. Please use my private set-off account, UCC Contract Trust account, for the adjustment of fees associated with this authorization. By your proper name, bond number, Social security number with no dashes, authorized representative. Now, on the bottom, I wrote void where prohibited by law. Now, that's a nice thing because you can't get in trouble for doing this. If it's prohibited by law, then it's void. So you can't get in trouble. Here is a sample of the notice of acceptance that I sent to the judge. Now, when you do your bond, don't send it to the clerk. You send this to the judge. And judges are bankers, okay? They have access to the accounts of commerce. They have access to our trust accounts, okay? Send it to the judge, and the judge will give it to the clerk, which is what happened in my case. Notice of acceptance and credit pre-authorization for sanctions and bond. I had some sanctions I had to deal with in this case because I hadn't showed up for the order to show cause because of the wrongful eviction that took place, but I did take care of that. Now, you put the name in the left-hand corner of the notary who is going to acknowledge your signature on this document. Name of the notary who is a witness for your proper name, the date, regarding account number, which is their case number, notice of acceptance, Honorable Judge Joe Brown, or whoever they may be. As it is my intent to expedite this process and reach settlement and closure on this matter as soon as possible, I have accepted your order to pay sanctions, this is in my case, dated 3/21/23, for value, or you can say, if you are the defendant, you can say, I have accepted the complaint. Endorse them, and am hereby returning them to you in exchange for the discharge of the charges using my private exemption number, Social Security number with no dashes, period. There are no facts in dispute, period. When you are the creditor, brothers and sisters, you don't go in there to argue. Debtors argue. Creditors go in there to resolve a matter, to settle the matter. Okay? There are no facts in dispute. My records indicate the balance on these sanctions is zero. If you have evidence to the contrary, or that my process for settlement is prohibited by law, please send a full accounting and the prohibiting law upon which you rely to the notary identified above within 10 days of your receipt of this notice of my acceptance. If you have no reasonable commercial excuse for denying the settlement of the account, please settle and adjust your records and send confirmation of the same to the notary identified above within 10 days of your receipt of my acceptance. In the event you choose not to respond to this notice and request, I will accept your silence as your agreement that the balance on the account is zero, and I will settle the account myself through registration. Also enclosed is the undertaking by personal sureties and bond. That is a form that I found, a court form for doing a bond, for providing a surety, which is very nice. Wonderful that I found that, and I filled out that form as well and sent it in as well. Supported by the UCC1 financing statement. The bond is for twice the amount of the damages sought in the second amended complaint to cover any associated accounts and to indemnify the court and the honorable citizens of the state of California. The credit is pre-authorized through the Secretary of the Treasury of the United States per HJR 192 and Public Law 7310. Respectfully submitted this day, by your proper name, authorized representative. And underneath, you would have your acknowledgement from the notary. The word bond is sometimes used more broadly to refer also to unsecured debt instruments. 1. You don't have to take notes for this. This is just to give you an overview. A bond supporting credit authorizations. This bond is the debt side of the implied contract that resulted when your grandparents took all the gold to the Federal Reserve banks in 1933. Now, they had to give us something in return when we did that. What they gave us was they have to pay for our debts since we are no longer able to pay for them with substance. A bond is always evidence of a debt. It's a liability to the debtor, but an asset to the creditor. You cannot be required to pledge your substance since there isn't any, but you can voluntarily pledge to help the United States through its bankruptcy status. A pledge is a bailment. A bailment is a delivery of goods or personal property, which, by the way, your body is your personal property. If you do not volunteer, you may be given choices to make it easier for you to volunteer. But you must always do this voluntarily. You are not asked to give your substance, only to pledge it, while you keep possession of the substance. In return, you get the implied bond. The straw man received a Social Security number. The correlating private side number is the exemption identifier number, which is the same digits, just no dashes. So the public debt number is 123-45-6789 for the debtor, the straw man. And the private exemption number is 123-45-6789, your Social Security number without dashes. The straw man is a creation of the debtor corporation. The government is a corporation. So is the state. So is the court. So, it is presumed to be an officer, agent, or employee of the debtor corporation. Brothers and sisters, are you an officer, agent, or employee of the government? Did you get any paycheck? No? Then that doesn't apply to you. It must file tax returns and must follow all the corporate laws and rules. The living man or woman, on the other hand, is not a creation of the debtor corporation, but it is the presumed representative of the straw man. The straw man can't sign any paperwork, guys, because he doesn't have any hands or fingers to write with. So that's why he needs you to do those things for him. The man is also the one who had the creditor side of the debt the U.S. owes. This is the national debt, at least part of it. Part of the national debt is owed to we, the people, who pledge their substance in return for an exemption from paying public debts. It's not that we don't want to pay them. We are not able to pay them. How are you going to pay a debt with another debt? You can't. The U.S. runs on credit. It does not have its own credit. Everything is backed by the full faith and credit of we the people. We have to have faith that the U.S. will honor its debts. And we have to know how to use our credit. The straw man cannot use your credit on its own, but it can use it if you authorize it. Our authorization is backed by the implied contract and the resulting bond, debt that the U.S. owes to the people. As long as the people are not acting like debtors and victims, they can use their credit. When the people start acting like debtors, And straw men, they dishonor their own heritage and rights. Your private instruments are backed by the bond. The number on the bond is 1, 2, 3, 4, 5, 6, 7, 8, 9 for your proper name. 2. Bond for discharge. The bills of exchange are government obligations and to the private investors. The banker's acceptances are government obligations. When you accept a presentment for value and sign it, you have just done a banker's acceptance. Public banks can also do a banker's acceptance. It is not designated to just one side or the other. Have you asked who is issuing the new money to the banks? Can the government issue money to the banks? Can other banks issue money to the banks? Where is the new money that is going to be issued to the banks? Where does the bank go when it wants to be issued more money? The people have always been private bankers in the states in America. Now we also have public bankers. The people used to dig the gold and silver out of the ground, have it minted, and then put into circulation. Now the people sign notes and give them to the banks to turn into debt money. And the banks put the debt into circulation as money. It would be against the law for the people to do that. They have to issue their credit money to the banks to do through the straw man. When you use the U.S. bond, even though it is an implied bond, to discharge a public debt, the debt is discharged, full stop. House Joint Resolution 192, go look it up, is the written public insurance policy guaranteeing this can be done. The people are still issuing new money to the banks by signing notes and giving them to the banks. 3. Appearance bond. This is a bond that assures you will appear in a court proceeding. It is not a catch-all bond that covers everything that will come up in the case. To get the appearance bond, you have to give your word, which is your bond, that you will appear to finish settling the accounting. It is issued by the hearing officer. If it is requested, and if there is no controversy, if you are honorable enough not to start arguing with the hearing officer or the complainant or the prosecuting attorney, you can get this bond. There must be no controversy. That fact is established by your voluntary act of accepting the charging instrument for value and returning it. In doing so, you are exchanging your exemption credit for the discharge of the charges. You are bonding your pledge to appear and settle. If it were not voluntary, that would be bondage. You must tell the hearing officer that you are not disputing any of the facts. Once you ask for the bond, you have it. It is yours. If you ask for it again, it will appear that you do not know you already have it, and the hearing officer will proceed as though he is talking to a debtor, straw man. A debtor or straw man does not automatically get an appearance bond. It may be required to pay for a bail bond. An appearance bond with conditions incorporates a cost to you. If you have requested the appearance bond at no cost to you, there will be no conditions to the release. If you do not ask for it that way, there may be conditions, like a drug testing, required meetings with court officers, or required daily or weekly phone calls. Those are a cost to you, as they take your time and your property. If you don't appear and settle the accounting, you will be in dishonor of your word, which is your bond, and the appearance bond will be revoked. They will not tell you it has been revoked. Your dishonor will then be used to carry out the presumption that you are representing the straw man in a fiduciary capacity and that you are in breach of your fiduciary duty. That is not allowed in equity. Then the debt of the straw man will be put on you. If there is not enough property held in the name of the straw man to cover the dishonor, or if you, as the trustee, refuse to turn over the trust property to settle the debt, they will take your body as surety for the debt. It is the trustee's body being taken. You volunteered to be the trustee. 4. Surety bond. The surety bond is used to subrogate liability from one party to another. It is similar to an indemnity bond. You can issue a surety bond to relieve someone who is in dishonor of potential damages, financial damages. You can indemnify an honorable party who may have made a mistake by volunteering to be his surety. This is often the case with a judge. If you do this, you are moving into a creditor position because you are taking responsibility for the actions of another. 3 parties are requested. 1, the one who is volunteering to be the surety. 2, the debtor. And 3, the creditor. There can be more than one creditor and more than one debtor. Creditor status can change during the case. When you become the creditor, someone has to be the debtor. The prosecuting attorney signed the complaint, and there is not bond in the case file, and there is no signed security agreement. He is going to be the debtor, the prosecuting attorney who signed the complaint. If he acts honorably and tells the judge he wants to settle or have the case dismissed, he stays in honor. You may have to authorize him to sign the check to settle the accounting. If he acts in dishonor, he is the one who will be left holding the bag. You can bond the parties and or bond the case. Charging order. A statutorily created means for a creditor, the plaintiff, of a judgment debtor, the defendant, who is a partner of others, you, to reach the debtor's beneficial interest in the partnership, your credit, without risking dissolution of the partnership. Uniform Partnership Act. The purpose of the court case is for the judge to test the facts of an accounting. He is the auditor in a possible dispute between a creditor and a debtor. The creditor always wins. It is a matter of how much the debtor will pay that is being determined in a court case. Number 6, case bond. This bond is in the nature of a replevin bond. A replevin bond was formerly used in common law, equity, when there was a dispute and one party chose to file a claim in court against another party in possession of property in dispute. The moving party was required to bond his charge, his claim, before he could get temporary possession of the subject property. The replevin bond was double the value of the subject property. Part of it was to indemnify the sheriff who seized the subject property from the defendant in possession. The order part was to guarantee the defendant would be reimbursed, at least for the value of the seized property, if it were not returned to him in the event he won the case. In equity, all charges need to be bonded. You have heard, put your money where your mouth is? This is what's happening when charges are brought in court and the moving party bonds the case. This policy assures the defendant will not be damaged by an unsupported complaint. Charges are rarely bonded in modern court procedures until after the case is decided. By that time, the defendant is almost always in dishonor. So the prosecuting attorney can use the defendant's dishonor to bond the case. It is really the defendant's representative that is bonding the case. Again, it is the man's credit that gives life to the bond. If the defendant is in dishonor because of what its representative, the trustee, said or did not say or do, it is the trustee's credit that is used to satisfy the debt or discharge the bond. You can voluntarily bond the case if there is no bond already in the clerk's file. Bam! Be sure to get a certified copy of the docket sheet as evidence there is no bond in the case before you issue your bond. When you bond the case, you are the creditor, and the creditor always wins. If you bond the case, becoming the creditor, and then dishonor the judge, the attorneys, or the process in any way, you will lose your position as a creditor and go back to representing the defendant. All the dishonors are pinned on the defendant, even if you are the one who went into dishonor through your words or your actions. The defendant cannot talk or act. It all comes from you. If you bond the case and underwrite the obligations, loss, cost of the honorable citizens of the state of whatever state you're in, that would include the attorney, as long as he is honorable. If he is not, he refuses the indemnification and volunteers to have his dishonor give the commercial energy to the settlement. It is up to him. The judge will go along with what he requests. Usually, the attorney will tell the judge that the plaintiff moves for dismissal. Rules of the game. Rule number 1. The fiction and the real cannot mix. The public and the private cannot mix. You cannot create a public debt. That is against the law. A creditor can issue a bond, evidence of a public debt, and use the bond to discharge other public debts. You cannot use the public Federal Reserve routing numbers on the private credit instruments you issue. Those routing numbers are public. Your credit instruments use your private routing number, EIN, with the closed account number. You are a private banker. The closed account number was accepted and put on a UCC-1. Your acceptance of the account number takes it to the private side for adjustment and set off. You gave notice to John Snow or Janet Yellen or his predecessor that you had accepted the account as collateral. Your secured party collateral rights are private. You are a secured party on the private side, even without filing a UCC-1. The UCC-1 is to give notice on the public side of your collateral rights. That is why you can use the account for adjustment and set off of public debts. There is no money on the private side. Debt is used on the public side to discharge public debts. There is no money on the public side either, but debt is accepted as money. The debts that are owed to you by the public can be used to discharge public debts. A debt is a liability to the debtor and an asset, a bond, each time you use your credit. You can bond your bill of exchange or just use a bond. Either way, it is a bond, evidence of a public debt owed to you that discharges the public debt. If the state cannot file a claim against you because it is a fictitious entity and you are a real living man or woman, then it must file a claim against a straw man to get to you. What is it trying to get? Does it want your body in jail? Does it want the money in your bank account, your house, your business? The answer is no. It wants your credit. Presentment has a complaint, a moving party. What is it trying to move? What is its complaint? It is usually using a statute as the grounds for the complaint. If public and private can't mix, the complaint must be against the public straw man, not you. Why would the state care if a piece of paper violated a fictitious law? What is the motivation? The state is trying to move you to let it use your credit. If you refuse, the state can move the court to grant the use from your dishonor. Does the state really have a complaint? Or is it just asking for your help? Maybe the complaint is that it's out of money. There is no money. None on the private side, gold and silver, none on the public side, except your credit. Does the office manager, what does he do when he needs more money for paper clips? It requisitions the guys on the top floor for money to buy more paper clips. Do the bosses say, no way, of course not? That would be counterproductive to the purpose of the business. Think of the state as your business. You need to be sure there are enough paper clips, or the business may fail. Why would you refuse to honor the requisition? Why you argue about whether or not the requisition form was filled out properly? Why would you deny you are the proper party to fulfill the requisition? Why would you ignore the requisition? Why would you get mad and start charging the messenger with fraud? If you ignore the requisitions and spend all your boss's money trying not to fulfill the requisitions, the business will fail. Where would that leave you? Your business is down the tubes. You might be in jail for breach of contract. Your property has been taken by the corporate attorneys. Your money's gone. All the people who depended on your business have to use other sources of your products and services. You are a very irresponsible businessman. If you had just signed the requisition, you would still be on the top floor. Instead, the trust assets are gone and you are making license plates. The state has no substance. It has no money. It has no inherent right to anything except what it has created, which is the straw man. It has a very important function. It has been charged with providing for the means by which you can go into grocery stores, gas stations, libraries, shopping malls, airports, car dealerships, and Walmarts. It does not get money from somewhere. If it doesn't get money from somewhere, it cannot continue to provide the infrastructure for you that you find so convenient. The only source it has is taxes. License, permit, and registration fees are a source of revenue for the state, but that is not sufficient for the giant octopus feeding machine we have grown to love and depend on. It needs to feed off your credit. And if you don't voluntarily let the state use it, the state will use your dishonor to take it. Have you ever had to ask your dad for financial help after you left his house and were out on your own? It is embarrassing. The state does not want to just ask if it can use your credit. It will have to find creative ways to ask for it, get it, and save face in the process. The trick is for the state to ask you for your help without the unenlightened person, U.S. citizens, being able to see it. The state must have your credit, and it is going to get it one way or the other. It is going to get it the easy way or the hard way. It is all up to you. Honor. Rule number 2, stay in honor at all costs. Your mission, should you decide to accept it, is to honor the state when it asks you, in its aggressive way, to let it use your credit, your exemption. The state is raising you up as a creditor every time it gives you a presentment. It is your choice. You can honor the state by accepting its presentment and issuing an authorization voluntarily for it to get enough of your credits to equal the value of its presentment, dollar for dollar. Or you can voluntarily dishonor the state by refusing, arguing, making it prove its claim, or defending the straw man pretending the state has no right to make its claim. Wow, that is a hard choice. You can voluntarily authorize the state to use your exemption, or you can voluntarily dishonor the state, at which time it will use your dishonor to take property from the straw man or take your body and collect rent while you sit in jail. Gee, what should I do? What should I do? There is an easy way and a hard way. The choice is always yours. Everything is by consent. The state is only following your lead. If you argue or defend, it gets to use your exemption and maybe take some of your possessions besides. If you accept and authorize the state to use your exemption, it is required to accept it. Full stop. What do you have to lose? Is your exemption limited? No. Can it be depleted? No. Remember, brothers and sisters, these are all just ticks in a book. There is no real money. What difference does it make if the state gets to use your exemption? The difference is the grocery stores and the Walmarts stay open. The fire department responds to fire calls. The garbage trucks continue to pick up your garbage, and the streets will be repaired. Now, when you understand how to stay in honor, it is a win-win situation. If you do not know how to stay in honor, it might be a win-lose situation with you losing, because the state will get what it wants either way. Rule number 3, there is no money. What do you use to pay your bills? If there is no money, what does the state use to pay its bills? Do you really have any bills? Whose name is on the contract with the electric company, the mortgage, the credit card, or the student loan? It isn't your name, it's the straw man's name. The Constitution says, no state shall make anything but gold or silver coin a tender in payment of debts. Well, there it is, a prohibition against the states. Does it say the United States or its agents can't use something other than gold or silver for payment of debts? No. Since there is no gold or silver coin in circulation in the United States, and all the businesses you have grown to love are in the United States, it is a good thing the United States has created a straw man for you to control and Federal Reserve notes for it to use. Or you would use money if you had some. The court presentment. The state or city or county or an agency has just honored you with a court presentment. It is a verified complaint or a grand jury indictment or a traffic ticket. Do you feel honored? No? Why not? Do you feel fear, anger, confidence you can defend your position? Let's analyze this situation. State is used in this writing generically as a general term representing any corporate, quasi-government organization and its agencies. You is used in this writing to represent the reader, the living soul. Straw man is used to represent an individual U.S. citizen, your name in all capital letters, but not a state as defined above. Now, what is this presentment? What are its components? It has your name on it. Stop. It does not have your name on it. It has the straw man's name on it. The moving party has named your straw man as a violator of a statute and has asked you to take responsibility for the violation. The state, city, county, or IRS cannot file a claim against you. The living man or woman. It is charging the straw man with a violation. Stop. It is establishing a value through an index associated with statute violations. This is ingenious. If you honor the presenter with an acceptance and return, the index established the amount of credit you will provide to the state. If you dishonor, the index establishes the amount of property the state will take to get the credits it needs. The presumption is that you are in partnership with the straw man. In some cases, the index establishes how many months the state will hold your body for breach of fiduciary duty while it collects your credits. It is suggesting a time period for you to answer. Stop. Don't trust this one. It establishes a time period for the straw man to answer on the public side, usually 20 days. But if you don't accept in 72 hours from the private side, you will be in dishonor. Now, don't let that stop you from going ahead and accepting it at whatever point you are at, regardless of how many days have passed. Don't let that stop you, but when you have the chance, do it within 3 days. That's the rules, within 3 days. The presentment is designed to help you into a dishonor. You don't have to go that way if you don't want to. It has the name of the party bringing the claim. Someone has to approach you and ask you for your help. That person is taking a big chance. By signing his name, he could end up owing the amount the state is asking the defendant to provide. This is usually an attorney. He signs his name to it and becomes the attorney of record for the plaintiff. State, through an attorney or other officer, has given you a court presentment, a request for your help. Options. You have options. Defend it, argue about it, conditionally accept it, ignore it, or accept it. You already know the right choice. You only have one good choice: accept. If you defend, you are refusing to take responsibility for managing the affairs of your business, the United States. Whether you want to admit it or not, the United States is your creation. It continues in business because you authorized it. If you argue, you are in a controversy with your own business managers. If you conditionally accept, you are requiring the United States to prove it has a claim, when it is in receivership and cannot have a valid claim against you without your permission. If you ignore the presentment, you are acting like an irresponsible creditor and will lose your status as creditor. Your only choice is to accept. That by itself is not enough, though. If you accept and return it, you have not carried out the promise you made when you accepted it. It's like signing the requisition form but not instructing anyone to write a check. You have accepted the presentment, the charges, but you have not given them what they need, your credit. It is like promising to pay the electric bill but never getting around to it. If you do this, they will turn off the electricity. When you accept the presentment for value, you have to follow through with some type of instrument. If you do not authorize the state to use your credit to settle the account after you have accepted it, you are in dishonor. If you do not authorize the attorney to use your credit to settle the court account after you have accepted, you are in dishonor. The state and the attorney will use your dishonors to charge their agents with authority to take the straw man's property, the sheriff, and or your body, the bailiff. Either way, the state and the court will get the use of your credit. The United States and its states are in receivership, so they have no credit of their own. They need your credit, and they will get it. The corporate counties and the cities are in this dysfunctional situation. They all need your credit. When they ask for it, give it to them. Follow through with your promise of acceptance and give them the use of your credit to cover, bond the charges. Be the creditor you can be. Take responsibility. The presentment is like a check. It is sent to you with a request for some kind of payment. If you endorse it and return it, they know you have approved the use of your credit. They can then use your endorsement, since they did not send a check made out to the straw man, to settle the debt account with an offsetting credit. They just need your authorizing signature to get the credit to enter on the books. Remember, there is no money. Remedy. Number 4, accept and return the court presentment. If there is an assessed value on the presentment, use accepted for assessed value and returned in exchange for closure and settlement of this accounting. If there is no assessed value on the presentment, use accepted for value and returned in exchange for closure and settlement of this accounting. 4. Attach an asset, an authorization for the state to use your credit. A bill of exchange is one of the instruments you can use to authorize the use of your credit. It is a writing, a bill, that you are giving the claimant in exchange for the discharge of the claim, debt, charges. It settles the immediate charge, requisition, full stop. It needs a date, an account number, which is the case number, a value, the name of the person who is to receive the credits, which is the court, the name of the public creditor, Secretary of the Treasury, the name of the public pass-through, your strawman, instructions, an instruction number, your name, the private creditor, your exemption number, creditor ID number, your signature. This is the endorsement. Instructions are very important. Non-cash items require instructions. If you do not understand them, don't send them with your instrument or do anything else until you understand what you are doing. Using other people's paperwork can be very, very detrimental to your success. Keep the instructions in plain English. These instructions are a great topic for discussion with your study groups. This is where the Treasury Tax and Loan Department, the TT&L, of the bank is incorporated into the process, and where the electronic fund transfer instructions are found. Be careful about putting information in boxes. It doesn't appear if it is in a box. Clerical information can be in boxes, but keep the substantial information outside the boxes. It is absolutely imperative that you understand there is nothing that is going to be transferred from the U.S. Treasury to the holder's bank. There is no funds transfer. There is no money transfer. There is no credit transfer. The credits are in your instrument with your signature on it, with a $ sign followed by digits greater than 0. When it is endorsed by the recipient and delivered to its bank, boom, the credits are already there. They just need to add to the account intended to receive them, and the use of the exemption needs to be approved by the Secretary of the Treasury. Approval is done through the TT&L department at the bank where the instrument is delivered. The electronic transfer is not a transfer of money, credit, or funds. It is a transfer of digital information from the Federal Reserve Bank through the federal window to the Treasury, where it can be approved or refused by the one who currently holds the office of Secretary of the Treasury of the United States, which is why it's nice to let them know what's going on. That is Janet Yellen at this time. She is also the one who keeps track of the national debt, which is partially owed to the people of the American states, who have funded the United States with their credit since 1933. She is the trustee on the Chapter 11 bankruptcy of the United States. All bookkeeping in the U.S. is done through her. When you use your exemption, the national debt is reduced in equal proportion. Janet Yellen, Secretary of the Treasury, has to keep track of the debits and credits on the national debt. You cannot leave her out of the equation. Letter of credit. When you authorize the use of your credit, you must arrange for that credit to be approved by a third party in public. Janet Yellen. When the presenter processes your instrument. If you don't do this, it is like writing a check on an open bank account that has no balance or insufficient balance to cover the check. The private side, when you use our exemption to bond your acceptance of a presentment, the public auditor must receive notice of your intent. That is Janet Yellen. The U.S. is not bankrupt, it is just in receivership. It can't make valid claims without an existing debt. but the state needs to get your credit anyway. The choice is yours. When the presentment is delivered into your hands, you become the holder. The state has honored you with presentment because you are in a position to help the state. When you endorse it as a holder, you are assigning the property, interest in some associated substance, i.e., your exemption, your credit, related to the presentment to someone else. If the presentment is signed by Jim Black, it should be returned to Jim Black. If the signature on the presentment is only a logo and there is no other signature, the presentment should be returned to the name and address on the logo or letterhead. In that case, no man has accepted the commercial liability for the presentment. That does not really matter. You are not doing a conditional acceptance. You are doing an all-out acceptance. You don't care about anyone else's liability because you are agreeing to be fully responsible. United States and all its officers, agents, employees had no commercial capacity to really make claims without evidence of an existing debt. That does not mean the state will not make it look like it is making claims. It needs your credit. So it is going to go through the motions of making claims. Do not embarrass the agents and point out that it has no commercial energy. It is your job to use your commercial capacity to fulfill the requisition without making it too obvious to the public. You are coming in from the private side to provide your credit for the public's use. Most of the public do not know the state has no commercial capacity to bring claims. Keep your superior knowledge to yourself. The public is not ready for full disclosure of this yet. Recap. Private administrative process. The notary sent your notice of acceptance with your acceptance and return. The notary sent a notice of non-response. The notary issued a certificate of non-response to you. The certificate establishes that you accepted and returned and exchanged your exemption for a discharge, that your acceptance was received and accepted by the respondent twice, that the respondent refused to respond or comply with your request, that there is an agreement of the parties. Since they didn't respond, that means they agree. That the respondent has no commercial energy to pursue collection since they didn't respond when they had the opportunity to do so. That you have all the commercial energy regarding the subject matter, that you are in honor, that the respondent is in dishonor. Court process. Some of it is private and some of it public. Accept for value and return the court presentment to the signing attorney. Attach a credit authorization with instructions for the attorney to use to settle the court accounting. Send a letter of credit to the Treasury. Get a certified copy of the judge's oath and accept it for value. Get a certified copy of the judge's bond and accept it for value. Give notice of your acceptance by a private mailing to the man or woman doing business as a judge. File a notice of acceptance on the public side. Get a copy of the court order appointing the attorney and accept it for value. Prepare a letter of instructions to be mailed to the appointed defense attorney and request bond. Check the clerk's file for a bond. Prepare your bond to bond the case. Remove the case to another court if necessary for judicial review of your administrative process. Get a certified copy of the judge's oath of office and accept it for value. That is evidence of the man's contract with the people, you, on the private side. You want him to take judicial notice of his contract with you. Filing it with a copy of the oath with the clerk will not accomplish that end, but it will give them notice that you expect the terms of that contract to be followed. You will have to enter the certified copy of the oath into evidence by filing it in open court to actually have it make any difference. Get a certified copy of the judge's bond and accept it for value. That is evidence of the limited liability the judge, person, has in public when dealing with citizens and residents that are either owned or controlled by the corporations. It does not limit the private liability that the man has when dealing with the people, you, on the private side. Since there is no money to pay you if you are damaged by the actions of the judge, you will have to be satisfied with possible payment to the straw man, the all caps, your legal entity, but that is not the reason you are bringing the bond into this issue. The reason is to notify risk management, if necessary, that you have been damaged by one of its insured persons. This is not the bond for the man, but a bond for the judge. The man is doing business as a judge for the public from time to time, but he can also come under the private rules of equity, which is broadly defined as what is right. It is right for this man to recognize you as a creditor, but only if you perform like a creditor and avoid going into dishonor. If you dishonor anyone, you will fit the profile of a debtor, the straw man, and he can ignore the private side. Give notice of your acceptance by a private mailing to the man or woman doing business as a judge, not for filing to the clerk. Mark the envelope private. Have a notary mail it by certified mail, return receipt requested, give you a certificate of service. The return address is the notary's address. The components of the letter are: you have accepted the presentment for value and returned it. You have exchanged your exemption for the discharge of the charge. You want settlement and closure. You are requesting an appearance bond at no cost to you. You are not disputing the facts. The parties have reached an agreement since they never responded to you. Then that means they agree. There is no controversy. You have accepted the judge's oath and bond for value. Include a photocopy of the notary's certificate of non-response from your administrative process to confirm there is no controversy. File a notice of acceptance on the public side. This will let the public know that you are doing something on the private side to settle the account. If you do not give notice to the public, it will be assumed you are standing mute. That is a dishonor. It results in default judgment or summary judgment. What would this notice say? It is your intent to settle and close the accounting immediately. You have accepted and returned the presentment. You have exchanged your exemption for the discharge of the charges. You are requesting an appearance bond at no cost to you. You do not dispute the facts. You will enter a plea for the defendant. You want to be advised of the details of the hearing to receive the bond and enter the plea. You are bringing the argument of the parties and the judge's oath and bond into the case. When the prosecutor signs the complaint, verifying it, and his signature is notarized, he is taking on the liability that may follow in the event it is discovered the complaint is not valid. He's taking a big chance, and that's why lawyers always have to bring their checkbook with them to court. Because at that point, he's the only attorney of record. He has filed a form of notice of appearance by filing the complaint or filing the grand jury indictment. He technically represents the defendant until someone takes his place. He is counting on someone appearing in the case to defend against his complaint. If that doesn't happen, he is the responsible party and liable for all the costs prayed for in the complaint against you or associated with the statute violation. If that does happen, he is off the hook almost 100% of the time. That is what happens. He is pretty safe taking the chance. Usually, the straw man named on the complaint gets a good attorney to defend him. That means the defense attorney has taken on the liability, right? Not so fast. He does not take on the liability until he signs a notice of appearance and files it in the clerk's file for that case. Once he is the attorney of record for the defense, Now he's on the hook. Now he has to get someone to take his place. The likely taker on the position is the straw man. Always a straw man named in the complaint, indictment, or traffic ticket. The straw man can't talk, so someone has to represent it. Usually that is you, because you have a point to make, or a lesson to teach, or testimony that will prove your case. Wrong choice. This is almost always the losing proposition. Really good, off-point paperwork has been put into court for decades with a very low success rate. The only way to win is to let the state win. I love win-win situations. How can you win and the state win at the same time? Well, if you accept and return the presentment and exchange your exemption for the discharge of the charges, the state gets the credit from your exemption and you get the discharge when you bond the case. Well, that sounds easy, right? If the defense attorney can get you to act as the trustee for the straw man named on the complaint, the defense attorney is off the hook too. It is just a series of passing the buck. It's a game of hot potato. The one who ends up with it has to pay the bill. The prosecuting attorney starts with it. It goes on to the defense attorney if he files a notice of appearance, and then on to the straw man if you volunteer to defend, argue, testify, or join in the action in any way. It eventually ends up in your lap. You are stuck with the public liability unless you accept and discharge it from the private side. Hot potato game, prosecuting attorney, defense attorney, straw man, you. If there is no defense attorney, it just passes to the defending straw man. If you accept, it stays with the prosecuting attorney. He has the power to settle the accounting if you authorize him to do so, because your bond is going to be backing it up. Now, brothers and sisters, I'm going to end this video here, but I have good news for you as well. I am going to offer a $20 telephone consultation to anyone who is interested in that type of thing. I'm sorry that it took so long for me to do this follow-up video, but it's important that I wanted to wait and make sure that I was able to use these processes myself and get results before I went and spoke about it at all on YouTube any more than I already have. And now I have full confidence because, like I said, the court has accepted my bond and it puts me in an excellent position. Now, what I offer are advanced legal strategies. I am not a lawyer. Please be advised. I do not offer legal advice. I offer legal strategies. And you can send $25 to paypal.me/kbartok and then send me an email to trueshoot@gmail.com. Let me know that you just booked a consultation. Leave your phone number, best time for me to reach you, and I will contact you right away. And if anybody is not happy with the consultation, they'll get their money back. This is an introductory offer, limited time only. If you don't want to use PayPal, you can put $20 cash in an envelope and send it to me. And with your phone number and the best time to reach you, and I will call you right away as soon as I get it. I'm definitely going to make some more videos now about this subject matter. And I just want to encourage you, if anybody is having trouble with their court case or with someone who's putting them through the ringer in court, just remember, gather your evidence, and then after they're done doing what they do to you, you're going to turn around and sue them back for what they did. If you want judgment, brothers and sisters, you got to bring it. You got to know how to enforce everything in this life. Take care, and I'll see you in the next video.